Good afternoon, Your Honor.
Who is that? See anybody?
We had our video off.
Yes. All right, let's get going. Who's ready to go?
Okay, on David Dixon, Your Honor, this is the one that you and I discussed, I think, yesterday afternoon late. That I had appointed him, amended the order and on the appointment on Richard Smith. And we're gonna set him for next Tuesday.
Okay. All right.
That's on David Dixon.
Cause number CR 22-269, State versus David Paul Dixon. Court sends Mr. Dixon's motion to revoke 926 as appointed Honorable Richard Smith.
Mr. Linder is ready on a plea. On Mr. Sandoval.
Good afternoon, Your Honor.
Good afternoon, sir. All right, Mr. Sandoval, this is cause number CR 13225. Ask that you raise your right hand. I'll place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Your name is Javier Reyes Sandoval, is that correct?
Yes, sir.
And Mr. Sandoval, are you a United States citizen who reads, writes, and speaks English?
No, I'm not. I'm not a U.S. citizen.
You're not a citizen. Do you understand that if the court follows the plea agreement today and convicts you of evading arrest or detention of the vehicle, I'm sorry, just evading arrest or detention, that may have adverse effects on your ability to remain in this country and or re-enter this country?
Yes, sir.
And have you consulted with your attorney or any other attorneys regarding that?
Yes, sir. We have, Your Honor.
Okay. And you are currently represented by Mr. Linder. Are you pleased with his representation of you?
Yes, sir.
Feel like you've had enough time to talk with him about the case, and you've had all of your legal questions answered?
Yes, sir.
And Mr. Sandoval, is there anything about the plea agreement paperwork that you've read and signed today that you do not understand?
No.
Mr. Linder, do you believe your client to be competent?
Do, Your Honor.
And you've explained to him his rights regarding this case, and as I guess you've already put on the record, you have advised him regarding potential immigration consequences.
I have, Your Honor.
Mr. Sandoval, you were, see what you were originally charged with evading arrest or detention of the vehicle, a third-degree felony. However, it looks like the plea agreement today would be to a lesser included offense, Class A misdemeanor, evading arrest or detention. That does carry a range of punishment of confinement in county jail not to exceed 1 year, or a fine, potential fine not to exceed $4,000. I see the plea agreement is that you plead guilty to that lesser included Class A misdemeanor. In exchange, the state would recommend that you be convicted and that you be sentenced to 4 years confinement. 44 days confinement in county jail, to which you would receive 44 days of credit already served. In addition, you would have to pay a $750 fine, $207 court costs. Is that your understanding as well, Mr. Sandoval?
Yes, sir.
All right, then at this time, I would ask you, how do you plead to evading arrest or detention in Class A?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, force, or pressure you to plead guilty today?
No.
All right, the court then accepts the defendant's plea of guilt. Mr. Linder, any objection to the stipulation of evidence?
No objection, Your Honor.
All right, stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor.
Anything further from the defense?
Question, Your Honor, as far as the fines and court costs, can the court give him credit for the time he served in jail? Or I don't know if he has the ability to actually pay that being that he's in jail. How does the court prefer to handle that?
How do I prefer to handle it?
Yes, sir.
Well, is that part of y'all's agreement? Did y'all negotiate that?
No, it's a fine and court cost, but I didn't know sometimes or to let them serve it out, or sometimes they'll make their family come pay it. I didn't know how the court would do it. We did not negotiate that as a part of the plea other than the amount.
Well, it's gonna be a judgment, so he's gotta pay it. If he can't pay it in stancher, then he'll need to appear at the courthouse and make payments, work that out.
Perfect, thank you.
Sorry, court's gonna review the evidence. All right, court has reviewed the evidence. Court finds that there's sufficient evidence to convict the defendant. Court does follow the plea agreement today. The court convicts Javier Reyes Sandoval of evading arrest or detention. Class A misdemeanor, assesses his punishment at 44 days confinement in the county jail. Issue him credit for time served towards his 44 days. With time served, court orders him to pay a $750 fine, $270 court cost, $15 reimbursement fees. Mr. Sandoval, when you do get out of jail, you'll need to report to the courthouse, make arrangements to pay your fines and court costs. Work out a payment plan if you cannot pay them all at once. Failure to do so will result in the court issuing a warrant for your arrest. Do you understand?
Yes, sir.
All right, Mr. Sandoval, I need you to step over with the deputy to be fingerprinted. Good luck to you, sir.
Your Honor, you have excuse?
Yes, and Mr. Linder, next time you appear in court, I need you to be wearing a tie.
Thank you, Your Honor. Will do.
Ms. Tabram, anyone else ready?
We go get it.
I'm sorry, Your Honor.
Is there anyone else that's ready?
I thought Mr. Manning was ready on, he's not. Okay, so can we have just a few minutes? But y'all are not ready, are you? Nolan and Jeff?
Yes, if it was the case.
Yeah, for secret, yeah, for secret.
Now, Bobby has to translate if you need to talk to him before.
Okay.
When you turn in your plea.
Yeah, that's like, oral monitor. Oh, and Laney, if I get Laney.
Jonathan, you have all your paperwork you need?
Yes, ma'am. I'm just waiting on my folks.
Ben Barton is in Henderson.
Thanks.
Thanks, that's what I heard. He's not in.
They're supposed to have brought them. They brought,
They didn't bring him in there, he's not, he knows him.
if they went and got candy.
I'll go look.
Yeah, see if they can fetch
I'll see.
them. Doesn't seem to be happy with that.
Yes, ma'am. Did anybody else come back with?
Yes, ma'am.
Got it. We're missing one.
I believe. I mean, don't be lying, but at least to them anyway. And if
Or
you.
maybe they're here, maybe they just kept them in there.
Corbin. Corbin. Bert. It's all dude. Tattoo on his neck.
Right. And then Jonathan, will you be ready?
I have one,
Your Honor,
have one ready, so we, I'm not gonna get brought up. Yes.
okay, we're ready. on, Mr. Patton's on J Penny.
All right, this is file number CR 22-390, State versus J. Warren P. for docket call. Go ahead, Mr.
Oh, Your Honor, Matthew Patton, I'm here with Mr. Penny.
Yeah, go ahead for docket.
Your Honor, the court was kind enough to have a hearing on the motion to suppress. And I filed a request for reconsideration because there was some findings of fact. The main one of which was the court found that the motor vehicle was owned by the driver, and I think it's clear in the offense report, the video statement, and I believe the officer's testimony that Mr. Penny actually owned the car. And at least it's our argument that at least that gave him a expectation of privacy that at least the court found that as an occupant he didn't have. So that was only our basis for the request for reconsideration.
Did you admit an offense report during the motion to suppress for the court to consider?
No, you're right. The court wouldn't have had possession of that, but I believe the officer's testimony and on the video, the driver was clear that it wasn't her car, and the officer, I believe, and I don't have the transcript, testified that it was Mr. Penny's vehicle because he was asking her, and I can't remember how much of the tape the court saw. You know, she had mentioned buying a car, and he says, "This is your car," and she said, "No, this is Mr. Penny's. You know, he's my boyfriend." But I don't have the transcript in front of me, Your Honor.
Okay, I'll take the motion in consideration. I'll review it. I watched the entire video multiple times and changed, so I'm pretty familiar with it. So I'll go back and rewatch that. It wasn't my recollection that he had inserted through her or anything else. I'll go back and rewatch. State, do you agree or disagree?
Your Honor, I don't recall the video myself. Although I just with how long this case has dragged on, I'd say that we're ready for trial.
Well, Your Honor, I think it'd be a brief hearing, a ruling by the court, and we could be ready. This is set next week, is correct?
I don't believe it's set next week in trial. I don't believe our next trial is until October 2nd. I believe we have a special setting, so I don't think this case is #1 for trial.
Oh, I apologize, Your Honor, but we'll be ready when the court tells us to. But the issue I've raised wouldn't take that long of a hearing, or could even be resolved without a hearing. Take your own.
See, so when did you file your motion for reconsideration?
It was this morning.
Okay, well, obviously I haven't had time to review that, so. Okay, I will set Mr. Penny for an additional docket call. I'll review the motion, and I'll issue the ruling before our next hearing. That will be. Let's come back on, are you available on October 10th or 12th?
I am available on the 10th, Your Honor.
10th, okay. All right, let's set it for another docket call, October 10th at 1:30. And I will look at your second motion to suppress and consider that, and I'll notify the parties.
Thank you, Your Honor.
Thanks.
Your Honor, we should have an interpreter at 2:00, so if you see them, we have him in here, but we also have another plea that we're ready on.
Let's go ahead and do the plea. I don't see the interpreter. Who is this?
This judge, this is Mr. Thomas Caps.
All right, Mr. Caps, this is file number CR 23-45. If you'll raise your right hand, Mr. Caps, I'll place you under oath. Mr. Caps, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help me God?
Yes, sir.
Thank you. You lower your hand. Your name is Thomas Allen Caps, is that correct?
Yes, sir.
Mr. Caps, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning's representation of you?
Yes, sir.
You feel like you've had enough time to talk with him about your case, that you're satisfied that you had all your legal questions answered and that you understand everything that you read and signed in your plea agreement?
Yes, sir.
Mr. Manning, you believe Mr. Caps to be competent, and if so, that he's entering into this plea intentionally, knowingly, and voluntarily?
He is competent judge, and yes, I believe he is entering in this plea intentionally, not only voluntarily.
Mr. Caps, you are charged with the third-degree felony offense of failure to comply with sex offender's duty to register for life annually. That does carry a range of punishment of not less than 2 years or more than 10 years in prison and a potential fine not to exceed $10,000. I see the plea agreement in your case is that you would plead guilty to that crime. In exchange, the state's recommending that court find you guilty, set your punishment at the maximum 10 years, but suspend that and place you on probation for 10 years, along with a $2,500 fine plus court costs and reimbursement fees. Is that your understanding of the plea agreement?
Yes, sir.
All right, then, Mr. Caps, how do you plead to failure to comply with sex offender's duty to register?
Plead guilty, sir.
You're pleading guilty to that crime because you are guilty of committing that crime.
Yes, sir.
Has anyone threatened or forced you to?
No, sir.
The court accepts the defendant's plea of guilt. Mr. Manning, any objections to the stipulation of evidence?
No objection to the stipulation as offered.
All right, that is submitted, and the court takes judicial notice of the defendant's judicial commission. Anything further from the state?
Nothing, Your Honor.
Anything further from the defense?
Rest in close, Judge.
Of course, reviewing the evidence. All right, court finds that there is sufficient evidence to convict Mr. Caps. However, the court will follow the plea agreement. The court convicts him of failure to comply with sex offender duty to register for life, third-degree felony. The court assesses his punishment at 10 years confinement in Texas Department of Criminal Justice. Court suspends that sentence today, places Mr. Caps on 10 years community supervision, orders him to pay a $2,500 fine, $290 court cost, $535 reimbursement. Mr. Caps, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. Step over to be fingerprinted and the probation officer will say.
Judges, are 2 o'clock interpreter on?
No, sir.
Okay.
Ms. Abraham, is Mr. Copeland and Ms. Chastity Smith, were they in the courtroom?
No, Your Honor.
Okay, well, Mitch Adams, okay, Leonard has just logged in for interpretation and bitches. So I'm going to be very busy, but Leonard is there. Now,
Okay, and then Mr. Adams is available.
yes, he just logged in.
Okay, and what about Mr. Weiner?
No.
No, okay. So we'll get those 2 in here while y'all are doing the interpretation.
Okay. Good afternoon, Mr. Morales. How are you, sir? Well, I'm getting the big boss today. I feel No privileged. It's either that or I'm worried that I'm doing something wrong and you can't respond. All right, Mr. Morales, if you will raise your right hand, state your name and your number, license number for the record, I'm gonna swear you in. Mr. Morales, do you solemnly swear that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? All right. Yes, sir. Yeah, he needs to put those on.
Sorry, Judge, you'll make a motion.
Yes. That's it.
Excellent. All right, this is cause number CR 22-191, State of Texas versus Jaime Rio Barrientos. It looks like we are set for arraignment today, Mr. Manning. Go ahead.
Yes, Judge, I had an opportunity to go over my client. His name is spelled correctly. He understands the charges against him. He enters a plea of not guilty at this point in time. Additionally, we went over the discovery previously, and I received an offer which I conveyed to him today. He would like to discuss that offer, and we may be able to get the case resolved in our pre-trial setting.
Very well. Court finds that Mr. Murillo has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record. Court will set this matter for a pretrial hearing. Mr. Manning, I think I've been setting you due to the Thursday requirements. The next Thursday I have is October 12th. That's not a whole lot of time. After that would be November 9th.
Judge, because we have an offer, I think we're close. I don't mind being set on the 12th.
Okay, all right. And obviously, if we don't reach an agreement that day, we can bump it out. So, all right, the court will set Mr. Murillo then for October 12th. That will be at 1:30, so long as he's in jail, 9 a.m. if he makes bail. And Mr. Morales, and before we conclude the hearing, if you could ask Mr. Murillo if he has any questions of Mr. Manning. All right, thank you, sir. All right, we'll see you back on October 12th. I believe that's the only case we needed assistance on today, so I'm gonna give you the rest of your time back and I'll not report to your superiors that you're not here. You said the quarter. Good to see you. Have a great day.
Okay, Your Honor, we have Chastity Smith.
All right, Mr. Adams here. Here's Mr. Adams.
Afternoon, Your Honor.
Good afternoon, Mr. Adams. We have your client, Miss Chastity Smith, in cause number CR 22-49 for pretrial. Go ahead.
Your Honor, we don't have any pretrial from Ms. Smith this afternoon. What I need to do is make a concerted effort to reach out to the district attorney's office, because I think we can have this resolved with the plea agreement quite possibly before we come back, or by the next time we come back.
Okay, all right, I mean, no pre-trial motions, we'll set this matter for docket call. I can set this as soon as, well, I can set it as soon as next week, but I would be resetting for October sometime, usually about 30 days, Mr. Adams. I can do something as early as October 10th, 12th, or 24th.
Your Honor, do you remember, well, no, that was a morning second. What were the dates again? 10, 12, and
24.
24? I guess, where's that? It's here. October 10th, please.
10th, yeah, I was gonna look to see your case this morning. Yeah, we did October 10th that same day. You can do that as well.
Ooh, that's gonna keep me there all day. But it's really the most, that's fine. That's fine.
October 10th.
Yes.
Okay. All right, we'll set Ms. Smith then for docket call October 10th
Yes, sir.
at 1:30.
Okay, Your Honor.
We have Mr. Copeland as well.
Yes.
CR 23-93 State versus Rusty Wayne Copeland. This is pre-trial on this case.
Yes, Your Honor. Is this the engaging?
Yes, sir.
Okay, I thought so. Your Honor, I don't have any pretrial matters right now for Mr. Copeland. I'm unsure of the DA's office's posture regarding Mr. Copeland. Of course, we had a trial. We tried one of his cases earlier this year, and at that time, he still had a remaining case pending. And since the trial, I think this case was indicted. So it's going to take a little bit of a conference between with Mr. Hartwell's office there and myself to see if there's anything that we can do to work this out without having to go back to a jury. So that's a long way of saying I don't have any pretrial right now. I think we need another pretrial here.
You anticipate any contested motions on this, or is it more just about trying to put the cases together?
Your Honor, quite honestly, I have not reviewed. I have not started reviewing the discovery in this case, and so I can't answer that question intelligently without. I don't know.
All right, what's going to set Mr. Copeland for an additional pretrial hearing? About October 24th, you want to do later in October, or you want to do early November?
I don't want to go that. I don't want to go out to November. October 24 is good, Your Honor. I'm available.
All right, court sets Mr. Copeland for pretrial hearing October 24th at 1:30.
Okay. Thank you, Your Honor.
You're welcome.
I think, unless I'm mistaken, I think that's all I have, Judge Menendez.
Yes, sir. Yes, sir. That is all on your paper.
Okay, thank you.
Okay, okay.
Bye-bye.
Yeah. Okay, Mr. Manning is ready on Cody Welburn.
Okay.
In about 2 seconds.
All right, court calls State versus Cody Lee Welburn, CR 2332, CR 2333. Is this gonna be a plea today, Mr. Lee?
Yes, Judge, a plea and a dismissal. We dismissing CR 2332. Terms of 33 are going to be pleading to the guilty to the unlawful possession of firearm by a felon. That's going to be punishment assessed at 20 years TDCJ. Institutional division, a fine of $1,000, weapon forfeiture. We agree to take unfiled DA 2022-1481, which is the possession of marijuana less than 2 ounces, into consideration. Judge, I would note that it looks like the enhancement paragraphs were incorrectly notated when I got the paperwork this afternoon. He is pleading true to the first enhancement, but not to the second enhancement. It shows on here that he's pleading true to that enhancement, which would bump our range of punishment up and make this plea ineligible. So I just ask that we fix that second paragraph, second enhancement paragraph, and the finding on that second enhancement paragraph.
So he's going to plead true with a finding of true to paragraph 1 and to paragraph 2 not true, correct?
Correct, Judge.
And what about court costs 290?
Correct.
Reimbursement fees,
20,
jail time credit,
285 days.
All right, Mr. Welburn, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
All right, lower your hand. Your name is Cody Lee Welburn, correct?
yes, sir.
Mr. Welburn, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning's representation?
Yes, sir.
Feel like you've had enough time to talk with him about the case, have all of your legal questions answered, and that you understand everything that you've read and signed today in your plea agreement?
Yes, sir.
Mr. Manning, do you believe Mr. Welburn to be competent?
He is, Judge.
You explained to him his rights as they pertain to the case.
I have.
And he's entering his plea agreement intentionally, knowingly, and voluntarily, correct?
He is, Judge.
All right, Mr. Welburn. The charge of unlawful possession of firearm by felon is a third-degree felony, does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison, with appropriate previous convictions that can be enhanced upwards, including a second-degree felony, which I believe in your case, a plea of true to paragraph 1 as contained in the indictment would increase the range of punishment to that of a second-degree felony, which would have a range of punishment of not less than 2 years in prison or more than 20 years in prison, and a potential fine not to exceed $10,000. You've heard Mr. Manning state the plea agreement to the court, have you not?
Yes,
And you understand and agree that that's your agreement with the state?
yes, sir.
All right, understanding those things, Mr. Welburn, I would ask you, how do you plead to unlawful possession of firearm by a felon?
Guilty.
And how do you plead to the enhancement paragraph and the content contained therein, enhancement paragraph 1? Is that paragraph true or not true?
True.
And the court will find that the state is abandoning paragraph, enhancement paragraph 2. Is that correct, Mr. Hartwell?
Yes, Your Honor, it is.
Okay. All right, then court will, so let me ask you, Mr. Welburn, has anybody threatened you to plead or forced you to plead guilty or true today to either of these?
No, sir.
All right, then the court will accept the defendant's plea of guilt and plea of true. Mr. Manning, any objection to the stipulation of evidence?
No objection is offered.
Then the court will the court will accept the defendant's plea of guilt and take judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just regarding the other cause, CR 2332, we did reach out to the victim in that cause and did not hear back. So we are in compliance as far as entering this plea goes and everything as far as that's concerned.
All right, and is that a straight dismissal, Mr. Manning?
Yes, Judge, it is.
Okay. All right, then, state or defense, whoever has a stipulation, can you read it to me? I don't have that available here.
Judge, I believe I have it. Hold on one moment. On or about December 10th, 2022, in Van Zandt County, I, Cody Wellborn, had a 22 caliber revolver in my possession prior to law enforcement arriving. I hid the revolver along with another firearm by burying them near my home. After my arrest and speaking with law enforcement officers, I led them to where they buried the firearms, and both were recovered. Prior to this incident, I was convicted of a state jail felony on March 11th, 2021.
Gotta let Ms. Grisham catch up. All right, then based on the evidence presented to the court finds that there is sufficient evidence to convict Cody Lee Wilburn of unlawful possession of firearm by a felon. Court will follow the plea agreement today. The court convicts Cody Lee Wilburn of that offense. Court also finds enhancement paragraph 1 to be true. Court finds that elevates the punishment to a second-degree felony, and the court follows the plea agreement reached between the state and the defense. The court assesses punishment for that crime at 20 years confinement in the Texas Department of Criminal Justice. Court orders a $1,000 fine, $290 court cost, $20 in reimbursement fees. The court awards Mr. Wilburn 285 days credit towards his sentence. And the court also forfeits the weapon seized in this matter as reflected in the judgment. Furthermore, the court dismisses under section 1245 DA 2022-1481 possession of marijuana plus 2 ounces. And the court entertaining the state's motion to dismiss and cause number CR 23-32, the court grants the dismissal of that cause. Mr. Wilburn, you hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. Good luck to you, sir.
Yes.
Judge, next up, we have Mr. Corbin Burton. Judge, we had reached an agreement and had request paperwork be prepared. However, it does not appear the paperwork matches our agreement. I don't believe we're gonna have time to get that resolved today. I request that we reset Mr. Burton to a future date so we can get the paperwork ironed out.
We can set that Tuesday or Thursday of next week.
Judge, if I may just have one moment.
You said that whatever the issue is, you don't think it could be resolved today.
Judge, this was a negotiation between Ms. Curry and myself. And it involves numerous, little more complicated movements. And there are several issues that are with the paperwork. And additionally, there's supposed to be 2 sets of paperwork, one for CR 2390 and one for CR 2391, I believe. I only have 1 set of paperwork at this point in time.
Okay. So you want to do Tuesday or Thursday of next week?
Judge, if we can do Thursday, that'd be fine.
All right, court will set Mr. Burton to enter his plea before court. Both causes on September 28th at 1:30. All right, Mr. White, who are you ready on, sir?
Your Honor, could we call Mr. Green?
Colton Castle Green, CR 2303. Good, Mr. White.
Your Honor, we had set this for docket call. We're on a failed PTI, and Mr. Green has got a case pending over in Kaufman County. I've been in touch with his lawyer over there. We're trying to get a resolution that includes both counties. If I could have 30 days, I think we'll be able to get that done.
Do you know if he is on a detainer for Kaufman County?
Your Honor, apparently Kaufman County didn't know that he had been transferred over here, and he had court on September 12th. And talking to Mr. Russell, the court had entered a NISI on him, so I don't think they probably have a hold. They should have had it in their records that they transferred him over here.
Is his charge in Kaufman same level or higher than this charge here? There is.
It's the exact same charge, Your Honor. In my understanding, talking to Mr. Russell, is they've received an offer over there. But right now we are trying to determine the rehab option. And Ms. Curry has indicated to me that she wanted to do some things here. Talk to Mr. Russell. He's going to talk to the prosecutor over there and see if we can't get this all kind of under one umbrella.
Yeah, another reason I was asking is I know we're at capacity here in the jail. I didn't know if maybe it would be wise to send Mr. Green back to Kaufman County, let him stay over there and resolve his case and let us pick him up.
That might be the best thing to do, Your Honor.
Okay, I'll talk to the jail staff about whether or not they want to do that. Do you know if he has another setting in Kaufman County?
No, sir. My understanding it hadn't been a setting because they actually thought it was a NISI, and it wasn't because he was in custody.
All right, let's set him off. Are you available on October 24th?
Yes, sir. I'll be able to.
Let's set Mr. Green for docket call October 24th. And in the meantime, I'll talk with jail staff about seeing if Kaufman County has put their hold on him based on that NISI, or if they've withdrawn the NISI and asked for a detainer.
Your Honor, I'll try to get in touch with Mr. Russell and tell him kind of what's going on, and he might be able to talk with court staff and get him benched back so they can start trying to get him resolved over there, and then we can do whatever we have to do here.
Yes, sir. I like that. Thank you. Ready on Mr. Bailey?
I am not ready on Mr. Phelan. I had sent Mr. Hartwell a message. I needed to talk with him a little bit about a couple things.
Okay.
Your Honor, I'm actually standing in for Mr. Mulder on Carl Caver.
Okay. Is Mr. Caver there?
Yes, sir, he is.
Mr. Caver, this is cause number CR 21-380, CR 23-137, State versus Carl Claude Caver Jr. Arraignments on unlawful possession of firearm by felon, retrial on act self-evident. Good.
Your Honor, Mr. Mulder is in Tarrant County today, and right before the noon hour, he texted me and asked me if I would be able to stand in for him as he was stuck in Tarrant County. I told him that would be no problem. We're here on an arraignment. Mr. Mulder indicated to me that he had received discovery on the case, and we just needed to reset this for a pretrial.
All right. So has he gone through the indictment with Mr. Caver that he spelled correctly, all that stuff?
Your Honor, I have not seen the indictments. Mr. Mulder requested that I waive arraignment, but I don't know if you can pull it up on the screen or not.
Yeah, give me just one second.
Your Honor, at this time, Mr. Caver understands what he's been charged with. His name's spelled correctly in the indictment, and at this time, he'll enter a plea of not guilty.
All right, court enters Mr. Caver's plea of not guilty, cause number CR 23-137, finds that he has waived the formal requirements of arraignment. Court will set this to run at the same time as pretrial and the other cause. We'll set this for October 24th for pretrial for both cases.
Your Honor, there's two cause numbers. I have the CR 23-137. What's the other cause number, please?
CR 21-380. CR 21-380.
Thank you, Your Honor.
Mr. Graham, I do have Mr. Minor on Zoom for Johnny Jr. for if Mr. Cooper's there.
He's here, Your Honor.
Hey, everybody.
All right, this is cause number CR 20-326, CR 20-239, State versus Johnny Jude Cooper Jr. Show Mr. Weiner there were several docket calls today.
Yes, Your Honor. And first of all, thanks for letting me appear via Zoom. I'm in between settings of Smith County, so I appreciate it. This case, I subbed in on this case while it was already set for docket call. I've been working with Ms. Curry towards a resolution on this case. Over the last couple of weeks, I've been tracking down some pretty significant, in my opinion, mitigating information that I received yesterday that I'd like to share with Ms. Curry in hopes of working out a resolution. I know you don't like asking for another docket call, but that's where I inherited the case, Judge. And so I do need a little more time to try and resolve the case.
All right, any objections from the state?
Your Honor, I'm not as familiar with this case. I did speak with Ms. Curry. She was expecting to hear something as of this morning and did not. I can't say necessarily that there's an objection, but just for the timeline record, Ms. Curry was expecting to hear something this morning and didn't.
I actually thought I had a case set this morning in your court, Judge, and I didn't. I did call text Miss Curry, and we just haven't connected. So I apologize for that miscommunication on my part.
How much time do you need, Mr. Weiner? A couple weeks or 30 days?
I think 30 days would be sufficient, Judge.
All right, what about October 24th?
Let me take a look at my calendar, Judge. That'll be fine.
Okay, so court will set for a final docket call October 24th at 1.
Okay, thank you very much, Judge. That's all I have. May I be excused?
Yes, sir.
Thank you.
That, Your Honor, I believe Mr. Manning is ready to finish his up.
You like next, Mr. Manning?
Judge, ready on Mr. Laney, that's gonna be a plea.
Mr. Glenn Laney, CR 21298. Mr. Manning, go ahead and walk me through the terms.
Yes, Judge. This was a probation case. Original probation was put on February 10th of 2022 for a possession less than a gram, state jail felony. The plea to that is going to be true on both counts. Punishment is going to be assessed at 9 months confinement with a balance of financial obligations, which includes $2,500 for fines, court costs amount of $290, and reimbursement of $240, as well as restitution in the amount of $180. Additionally, Mr. Laney has 188 days credit. And he will be paying true to both counts D and M1.
All right, thank you, Mr. Manning. All right, Mr. Laney, if you'll raise your right hand, please show the oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, lower your hand. Make sure you speak up loudly and clearly for me so I can hear what you have to say. Mr. Laney, you appeared before the court on February 10th of 2022. You pled guilty to possession of a controlled substance under Group 1. Court heard the evidence that day, followed a plea agreement. Court convicted you of that offense, punished you with 18 months confinement in the state jail division of TDC, but the court, based on your plea agreement, suspended that sentence and placed you on probation for 2 years. It was during that period of probation that the state has filed its motion to revoke on April 4th, 2023. And as you can see, as I'm displaying on the screen here, these are the counts that have been alleged against you. The motion contains a total of 8 counts. Have you had enough time to review this motion with your attorney, Mr. Manning?
Yes, sir.
Are you pleased with Mr. Manning's representation?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. Manning, do you believe Mr. Laney to be competent?
I do, Judge.
And you said that he's pleading true to which counts of 1 through 8?
Well, Judge, I'm looking at the motion that you just pulled up. What's the file date on that?
4/4/23.
Okay, I have one that's dated 4/4, and it seems to be missing a sheet, and then the judgment says we're pleading to counts D and M1, which is all that's contained in my copy of attached motion. I'm not sure where the other page of the motion went. But if you'd like, I can discuss those other, we had previously, my client and I had previously discussed those other counts. But they are not contained, like I said, in the attachment for this plea. Want to just supplement that? I think we'd be fine with that.
Do you know which counts D and M1? Which
Yes,
count?
Judge.
The first two?
D is failed to report, right there in count 1, and M1 is failed to pay.
So the judgment only says those two counts.
That's correct, Judge.
Two, okay. So I guess however y'all want to proceed, the state could abandon counts 3 through 8, not change its judgment, or the state can amend and correct the judgment with M2, M3, M5, O, B, and W. What says the state?
Your Honor, if I could have just a moment to look at that and get you an answer in just a moment.
Judge, this is what we have right here is, I don't know if you can see that.
Your Honor, after looking at it, we would abandon the other counts and proceed only on the ones that are on the judgment.
All right, thank you, Mr. Earl. All right, then, Mr. Laney, I want to ask you as to counts 1 and 2, how do you plead? Are those counts true or not true?
True.
Are you telling me that those counts are true because what's alleged in those counts is in fact true?
Yes, sir.
Does anybody threaten or force you to plead true today?
No, sir.
All right, or will accept the defendant's plea of true to counts 1 and 2 at this time. Mr. Manning, any objection to the admission of the defendant's waiver of rights to plea of true and evidence?
No objection.
That is submitted or takes judicial notice of the defendant's judicial position. Anything further from the state?
No, Your Honor.
From the defense?
Nothing from defense, Judge.
All right, based on the evidence, the court finds that Mr. Laney has violated the terms and conditions of his community supervision. The court, having found count 1 and count 2 is true, the court hereby follows the plea agreement, revokes his community supervision, assesses punishment at 9 months confinement, state jail division of TTC, orders him to pay the balance of his financial obligations, awards him 188 days credit towards his sentence for the time spent in jail on this cause, and the court finds that the state has abandoned counts 3 through 8 respectively. Mr. Laney, you're hereby remain into the custody of the sheriffs. We carry out the terms and conditions of the sentence. Step over to be fingerprinted with the deputy. All right, who do you have with you, Mr.
Judge, this is Mr. Mosley. He just arrived here today from TDC. We're here for arraignment. I have not had an opportunity to go over the indictment with him. So if we could just briefly go over that.
Do you have a copy there? Or do I need to assist you?
I don't have a copy, Judge. I apologize.
I'm charging as much for today as I usually do, so.
When I last checked yesterday, he was still not here, and so I figured we had got the goods weren't served. Judge, we've had an opportunity to review that. I appreciate that. His name is spelled correctly. He understands the charge against him. Is as a repeat felony offender, 599 or life. At this time, he pleads not guilty and requests to be set on the pretrial docket.
All right, the court will find that Mr. Mosley has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record. Court will set this matter for pretrial on November 9th.
Is that the Thursday?
Yes, sir.
Okay.
Be ready on next.
Mr. Ryan Higgins.
Mr. Higgins, CR 23-129. Mr. Higgins, I have set on status.
Yes, Judge. I believe Mr. Higgins was not previously in our custody. He was recently brought here and then I guess to Henderson County based on his address out. I received a revised offer from the state last week and not had an opportunity to go over with my client as he is down in Henderson County. I'm going to ask to speak to him after court today and discuss that offer with him, and we'll see where we go from there. I request that we be set on the pretrial docket. And if we can get that November 9th date.
He's let's see. Well, remind me what the status was about.
He was out of county.
So he's look at this case.
This is his third setting.
Yeah, I was trying to see, make sure that he had been arraigned. Looks like maybe we arraigned him in June.
Judge, I was reappointed for Mr. Gimmel. That's why I'm not calling. But yes, I was reappointed for Mr. Gimmel.
Yeah, it's been a minute since I've looked at this one too. Okay, all right, court will set Mr. Higgins in for pretrial hearing on November 9th. 1:30.
Judge, next ready on Mr. Nava.
Alexis Nava, CR 20-25. Nava's on motion to vote, please.
Judge, my understanding is that Mr. Nava was just recently indicted on count 1 of the motion to revoke. And so we request additional time to review that discovery and see about negotiating a settlement to resolve all issues.
Is that a very recent indictment? Like
I believe it's the last grand jury, Judge.
Okay. Ms. Abraham, do you know when those sets of indictments went up for arraignment?
Your Honor, I have not received the list from the clerk's office.
Would you
And
recommend?
the only way I knew, Judge, was because my client was able to tell me that he got paperwork.
All right, let's set Mr. Nava then for November 9th.
Yes, Judge.
Ready on Mr. Ozuna?
Yes, Judge.
Mr. Ozuna? CR 22-385, CR 22-282. Set document all the thing.
Yes, Judge. Discussed this case with Ms. Curry and received a new offer. However, based on my vacation this last week, I was unable to get to speak to Mr. Ozuna about the new offer and its implications. I'm planning on speaking with him tomorrow during my weekly visitations, and so I request additional docket call on his case.
How about next Thursday?
Yes, Judge.
Court's going to reset for a final docket call for Mr. Ozuna, 9:28 and 1:30.
Judge, Mr. Ozuna just informed me he would like to make a statement about his case. It looks like he's written a short statement. I don't know what's contained within it.
I would ask that you review that first, Mr. Manning, and if it's not an issue regarding representation, then I'm not interested in hearing it.
Yes, Judge. Let me have just a moment.
Mr. Hartwell,
Yeah,
could you call Mr. White Nolan, please?
yes.
Your Honor.
Yes, ma'am.
You didn't answer me, but you were on mute.
What did you say?
I said you wouldn't answer me, but we were muted. Can we go ahead with Mr. White's plea? On
Oh,
Mr.
yes. Yeah, which plea is this?
This is Dylan Blue. We're doing felony information.
Oh, this is the right end. Okay, just 1 second.
Oh, I didn't say Mr. White, I'm sorry.
We're told.
I didn't tell you which Mr. White, I'm sorry.
Well, I figured it out. It took me a minute, but I figured it out. I'm still a little upset at Mr. Jeff White. He said that he didn't want to hear my opinion earlier on his other case this morning, and it kind of hurt my feelings.
Well, it might have been. I was a little bit scared of it.
You did get a good laugh out of it.
It was good. It got my day going. Function.
Judge, you want me to start?
No, that's okay. I'm reviewing this information real quick.
Oh, okay.
Right, and Mr. Blue's waiving indictment today, is that correct?
That is correct, Your Honor.
And he, it's either in the admonishments or he's filled out a separate form on waiver of indictment, is that correct?
Well, in the admonishments as well as a separate piece on this. Your Honor, the cases of what we are waiving indictment for and trying to get this thing over with is Mr. Blue will be going to, if the court goes along with our agreement, Mr. Blue will be entering Gideon's rehab facility in Winsboro on Monday. They are not allowed to take him today as we originally was hoping for. But that is part of what we're trying to expedite this for.
Okay. And what are the terms of the plea today?
Your Honor, this is going to be 5 terms. $1,500 fine, cost $290, restitution $180, and a reimbursement fee of $15.
How much is reimbursement? 15?
15.
15.
15.
Are there any 1245s?
Yes, there is. A unlawful carrying of weapons. Weapon forfeiture. I guess another charge of manufacture, delivery of controlled substance, only group 2 or 2A. 4 grams, less than 400.
You said PG2.
PG2, that's correct, or PG2A.
2A, 4 grams to 200.
That's correct. That is also the charge that we have in front of you right now on the felony information.
All right, Mr. Blue, this is cause number CR 23-00169. Can I raise your right hand, sir? Do you swear that the testimony you give to the court today would be the truth, the whole truth, nothing but the truth? So help you God.
Yes, sir.
Your name is Dalen Blue, is that correct?
Yes, sir.
Mr. Blue, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you are represented by your attorney, Mr. Jeff White. Are you pleased with Mr. White's representation of you?
Yes, sir.
You feel like you've had enough time to discuss the case with him, have all of your legal questions answered, and that you understand everything that you've read and signed in your plea agreement?
Yes, sir.
Mr. White, do you believe Mr. Blue to be competent?
I do, Your Honor. I believe he's able to make the decisions that he's made today.
All right, Mr. Blue, you are charged with the first degree felony offense of manufacture or delivery of a controlled substance penalty group 2, greater than 4 grams, less than 200 grams. A first degree felony does carry a range of punishment, not less than 5 years in prison, or more than 99 years, or life in prison, and an optional fine not to exceed $10,000. Now, the fact is that you've not been indicted on this case, and no person in Texas can be held over for prosecution without an indictment. That indictment has to be returned by a grand jury. Now, you have the absolute right to have your case presented to a grand jury, but you also have the right to waive that right and proceed on an information, which appears to be what's going on here today. Is that what you are wanting to do in your case, is waive your right to a grand jury, allow the state to just file an information on their own, prosecute you so that you can resolve your case?
Yes, sir.
And you understand, Mr. Blue, that once you waive your right to a grand jury and we move forward, you're not going to get that right back. You don't get to go down to rehab or, in a few months, if something happens, you get a revocation, you don't get to come back and say, hey, now I want that grand jury. You understand that once you waive it, it's gone.
Yes, sir.
And you're doing that because that's what you want to do, and you're making that choice intelligently, knowingly, and voluntarily. Is that right?
Yes, sir.
All right, and Mr. White, you join in with Mr. Blue in waiving his right to a grand jury. Is that correct?
That is correct, Your Honor. Mr. Blue is looking forward to going to rehab.
Okay. Court will approve the waiver of indictment in this case, finds that Mr. Blue has been admonished as to his right and has waived the same intelligently, knowingly, and voluntarily. Mr. Blue, if the court follows this plea agreement that you heard your attorney, Mr. White, read into the record, you understand that if you violate any of the terms and conditions of your community supervision, the state of Texas, the prosecutors could file a motion to adjudicate your guilt, that means convict you, and they could ask the court to conduct a hearing to receive their evidence. And if they prove that you have violated any of the terms of your community supervision, the court could do a lot of things, including finding you guilty, revoking your community supervision, and assessing punishment anywhere from that minimum 5 years in prison all the way up to 99 years or life in prison. That's the biggest range that we have under Texas law. So it's a serious risk. That's a serious disadvantage of a deferred adjudication. The advantage is, though, that if you complete all of the terms and conditions to do what you're supposed to do, then the case can be dismissed going forward. Okay, so understanding all of that, do you still wish to go forward?
Yes, sir.
All right, then, Mr. Blue, having admonished you as to the range of punishment, advantages and disadvantages of deferred adjudication plea, I would ask you at this time, how do you plead to the first degree felony offense of manufacture or delivery of controlled substance penalty group 2?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime and for no other reason?
Yes, sir.
All right, and Mr. Blue, has anybody threatened, forced, or pressured you to plead guilty today?
No, sir.
Court does accept Mr. Blue's plea of guilt. Mr. White, any objection to the stipulation of evidence?
No objection, Your Honor.
Court admits the stipulation of evidence and accepts Mr. Blue's plea of guilt at this time. It also takes judicial notice of his judicial motion. Is there anything further from the state?
No, Your Honor.
Mr. White, anything further from Mr. Blue?
No, Your Honor.
All right, and I don't have the stipulation of evidence here with me. Can someone read that into the record for me? Mr. White, do you have that stipulation of evidence?
Yes, Your Honor. On or about February 5th, 2023, in Van Zandt County, I, Dylan Blue, was lawfully stopped in Grants Plain by Mackenzie Chandler for not having a front license plate and crossing slightly into opposing traffic lane. Officer Chandler conducted a probable cause search of the car, and after a passenger handed him a glass pipe that could be used to smoke methamphetamine. During the search, Officer Chandler found several baggies, scales, marijuana, and a bag that had 15 1-gram cartridges that contained Delta-9 THC. The labs tested and confirmed one of the cartridges it was my intention to sell some of the cartridges. I don't know if we can actually agree with that.
Well, I think it's already in the evidence. I've already.
Well, since February 5th, I have taken steps to get away from people I was with and to help get my substance abuse problem, including being admitted into a rehabilitation facility, which I'll be entering shortly after this plea, which is absolutely correct.
Now, if he didn't intend to sell it, that would defeat the manufacturer and delivery charge altogether, right? If he was just possessing without intent to deliver.
Judge, I don't think we're in a place where we can contest it.
I mean, if you and Mr. Hartwell need to talk about it, I may consider letting him withdraw.
I will go along with the theory that the state does believe that.
Okay. All right, then based on the evidence presented to the court finds that there is sufficient evidence to convict Mr. Blue of this offense. The court will follow the plea agreement today. The court defers the finding of guilt, places Mr. Blue on deferred adjudication for 5 years community supervision, orders him to pay a $1,500 fine, $290 court cost, $180 restitution, $15 reimbursement. Court dismisses under section 1245, unlawful carrying of the weapon, along with weapon forfeiture of the weapon seized in that matter, and also another manufactured delivery of the controlled substance delivered to a 4 grams to 200 grams. Mr. Blue, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. You have any questions?
Yes, sir.
All right, step over with Deputy Martinez. He's going to take your fingerprint. The probation officer will give you more information.
Thanks, sir.
Anything further, Mr. White?
I have nothing further, and I want to express my appreciation to the DA's office for helping us get this done and getting him into the rehab center.
Thank you, Mr. White.
Where's that? Okay. You know what's number one? Are you ready? Your Honor? Yeah, I need
Yes, ma'am.
Okay, I think we're down to our last one.
So let me know when you're not thinking about it. You know.
Oh, we are ready.
Oh, you're ready. Okay, yes.
Let's go back.
I think
Okay, maybe I'm ready and
Yeah, see, you're still thinking about it. You need to think longer.
no, I'm not thinking about it. I was ready.
So we have Mr. Failing and then we have Mr. Ozuna. Those are our last two, right?
We're already through with Mr. Ozuna.
I think so.
Yes,
I think so.
he's already gone back and Mr. Manning's already left. It was like a 6-page letter.
Well, I was still expecting some kind of announcement. I mean, I think I've set him already, but I was going to entertain what he wanted. I was necessarily let him read something to me, but I was wondering if, well, actually, I don't know that I have set him. Oh, yeah, I have. I said in final docket call.
Okay, let me,
That's okay. That's okay. If he, I just expected to hear from Mr. Manning, whether it was something that I needed to address or not.
Oh. I don't know. My dad's answering.
All right.
Deputy Martinez said, no, it was not.
City and state.
It was a long, please, help, I know. Was those things that
Yeah, that.
Yeah, Your Honor, we're ready.
All right, stay right on, ready. We get our paperwork fixed.
I think so, Your Honor.
This is.
Mr. Bowling, will you come sign real quick? We'll get that pen still. Give that to Mr. Clark. Good to be under. Do you need to tell them? I'm gonna make a copy of the document. That's all you'll need, right?
Sure.
We need. And then I can just go ahead and take it.
So we will that.
Yeah, Mr. Failing, how are you, sir?
Doing fine, thank you.
All right, this is cause number CR 23-96, State versus Kenneth Dale Failing. Mr. Failing, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Mr. Failing, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you?
Yes.
You feel like you've had enough time to discuss your case with him, have all of your legal questions answered?
Yes.
Do you understand everything that you've read and signed in your plea agreement?
Yes.
Mr. White, do you believe Mr. Failing to be competent? If so, have you explained to him his rights under this case? And also, do you believe that he's entering into this intentionally, knowingly, voluntarily?
Your Honor, I believe Mr. Failing is mentally competent, that he understands the proceedings that are pending against him here today. I have gone over a number of documents with him, as the court would know that this is a sexual offense, and should the court go along with the plea, Mr. Failing will be receiving 10 years deferred adjudication on an indecency by contact, which is a lifetime registration. I've informed him of that. I've gone over the statute to the best of my ability. As the court knows, it's a very complex statute. I've explained to him the steps he needs to take. He's also talked with Ms. Burns about who he needs to talk with over at the probation office. So I'm satisfied that we have met all the requirements as far as notifying Mr. Failing of his duty to register. And as far as deferred adjudication, I've gone over the advantages and disadvantages and what can happen with that should he so violate it.
All right. And as to the other terms, so it's 10 to the recommendation is 10 deferred on a lesser offensive indecency with a child, sexual contact, a second-degree felony. Is there a fine recommendation?
It's $2,000, Your Honor. Is that correct? Well, that's what I thought.
That's correct, yes.
$290 court cost, any reimbursement fees?
Let me grab the judgment, Your Honor. I'm not showing $20 reimbursement fee.
Any 1245s?
Your Honor, there's a 1245 control number 2022-0360.
And are there any special conditions of community supervision regarding victim contact or anything of that nature?
I do not believe we put any of those in there at this time, Your Honor. It's my understanding. There is a CPS case still going. So, okay. At one point, Your Honor, there's a CPS case going on. You know, I've informed Mr. Failing that he is not to have any contact with the alleged victim, and which will be the victim once the court takes the plea.
And is the alleged victim, in this case, is it a related family member, someone that he's gonna?
It is, it's his granddaughter, Your Honor.
I would expect that that would be a basic condition of community supervision. If it's not in there, I'm gonna require that it be in there.
That's absolutely reasonable, Your Honor. In fact, I had told Mr. Failing that would typically, off the top of my head, I can't, normally I would expect to see that in there. We've had some paperwork issues, but just for the record, so nobody's surprised, I've informed him that he's not to have any contact with her while she's still considered a child.
Thank you, Mr. Wright. And before we go any further forward, Mr. Hartwell, is there a victim impact statement? Is there victim compliance, victim agreeable, disagreeable?
Your Honor, there is no victim impact statement in this case. We are in compliance though.
All right, so y'all sent out the victim impact form and no one responded.
Correct, Your Honor.
All right, Mr. Failing, the range of punishment for a second degree felony offense of indecency with a child by sexual contact is a minimum 2 years in prison to a maximum 20 years in prison if convicted and sentenced, and a fine not to exceed $10,000. If the court approves this plea agreement and you're placed on deferred community supervision, if at any time during your period of community supervision you violate any of the terms and conditions, the state could file a motion to adjudicate your guilt, bring you back for a hearing before the court, and the court, upon hearing the evidence, if the court finds that you violated any term or condition, the court could do a multitude of things, including adjudicating your guilt, convicting you of the offense, revoking your community supervision, and assessing your punishment all the way up to the maximum 20 years or all the way down to the minimum 2 years in prison. Do you understand the risk inherent in that plea agreement?
Yes, sir.
Understanding that you still wish to go forward?
Yes, sir.
All right, then at this time I would ask you, Mr. Failing, how do you plead to indecency with a child by sexual contact, a second degree felony?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Correct.
Has anyone threatened or forced you to plead guilty?
No, sir.
The court does accept the defendant's plea of guilt at this time. Mr. White, any objections to the stipulation of evidence?
Your Honor, we have no stipulation or no objection to the stipulation.
All right, then the stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
Very quickly, Your Honor, just the court had a question about, I didn't recall seeing anything specifically referencing the victim in this case, but condition U, which Mr. Failing and I did talk about this yesterday when I came out. He's not supposed to have any unsupervised contact with minor children under the age of 18 and not to attempt to reside in a household where minor children live unless he goes through any of the goes through the community supervision department in order to get that. But I did tell him he was not supposed to have any contact with the alleged victim in this matter.
Thank you, Mr. White. All right, I don't have the stipulation of evidence here with me. I need someone to present that to the court.
Mr. Harwell, you want me to do it or do you want to do it?
Up to you, Mr. White. I can if you don't have it in front of you.
I've got the stipulation in front of me, Your Honor. I'll read the stipulation if that's okay with the state. Stipulation states on or about February the 23rd, 2023, Van Zandt County. I, Kenneth Failing, was arrested for indecency with a child by sexual contact in 2015 or 2016. My granddaughter, AL, who at the time was under 14, was living with me. At some point, I touched AL's vagina through her clothes for sexual gratification. This also happened in Van Zandt County since then.
Thank you, Mr. White.
And it says in there that he sought counseling. He's gonna have to go through counseling as a condition, so. But I agree to the facts.
All right, thank you, Mr. Wayne. All right, then based on the evidence presented to the court will follow the agreement of the state and on the state's recommendation. Court will defer a finding of guilt on the crime of indecency with a child by sexual contact and second-degree felony. Court will, what's the duration? It's 10 years, correct, Mr. White?
Yes, sir. And then this is a lifetime registration offense.
Court will place Mr. Failing on 10 years community supervision. Court orders him to pay a $2,000 fine, $299. $290 court costs, $20 reimbursement fees. The court dismisses under section 1245, cause number DA 2022-0360. In addition, the court will find that Mr. Failing has been prosecuted for an offense that requires chapter 62 registration, and the court finds that this is a lifetime registration. Has Mr. Failing been provided with a copy of chapter 62 as required by the code?
Yes, sir. We discussed.
Okay. All right, Mr. Failing, you're hereby remanded to the custody of the probation department so they carry out the terms and conditions of the sentence. Please step over with the deputy to be fingerprinted. Is that all? Thank you, Mr. White. I appreciate your work.
Thank you, Mr. Hartwell.
Thank you, Mr. White. And thank you, Judge.
You're welcome. Thank you, Chris. Anything further, Mr. Abraham?
No, sir. I think Ms. Burns should already be back there to have your signature and we will be there shortly.
Breathing on my neck right here.
All right.
Tell Deputy Martinez I appreciate your work. Hey, oh my gosh, hey, you got to give a guy a warning before you stick your face in front of the camera.
Yes, sir, I'm sorry.
All right, thanks.
Hey, Patty.
Kara's got a question for you.
Yes, ma'am.
I didn't know if you heard me on the printer.